Welcome to the Pipeline Podcast. Today is Wednesday, August 6th, and we have a very special episode for you tonight. So we're going over the Durham Report, which is like a special counsel report on Russiagate. This report takes place after the Mueller report, and to my understanding, it's the best source on Russiagate and the most recent, like, full source on it. And I haven't read it, and it's going to take a while. So tag along, check out the episode with us, see how well we can all follow this report. And then, at the end of the episode, you'll be able to say, like, you fully read the Durham Report. I'm going to read it to you. Previously on the channel, we went over Hunter Biden's laptop and how that story was kind of suppressed by mainstream media and social media. And Russiagate is kind of a similar story, so that's why we're going to go over it today. And then in the following weeks, we're also going to cover January 6th and kind of tie them all into a series and talk about it. So without further ado, let's check out our source. It's just a PDF of the Durham Report. So if you want to follow along, just Google search Durham Report PDF, and you can just download it right from like a government website. I don't have the link here. This is like the file location on my computer, just because it's a pretty big PDF. So I tried to pull it up from the direct source. It was just kind of like laggy. It was a lot for my computer to handle. So I figured, I'll just download it and pull it up. But either way, this is the source. And then once we're done with this, there's another declassified testimony that was recently declassified July 28th, 2025 about this Durham report. So there's some more information about it. A lot of this stuff is redacted, but we'll take a look at this when we're done. So let us begin. Sit down, shut up. We're going for a ride. It's going to take a while. So it was John H. Durham and the special counsel. They did this report for the Attorney General Merrick B. Garland in May 12th, 2023. Subject: report on matters related to intelligence activities and investigations arising out of the 2016 presidential campaigns. The attached report is submitted to the Attorney General, which states that at the conclusion of the special counsel's work, he shall provide the Attorney General a confidential report explaining the prosecution or declination decisions reached by the special counsel, in addition to the confidential report required by Section 600.8c. The Attorney General has directed that the special counsel, to the maximum extent possible and consistent with the law and the policies and practices of the Department of Justice, shall submit to the Attorney General a final report in a form that will permit public dissemination. This two-part report, unclassified report and classified appendix, is presented in fulfillment of these requirements and sets forth our principal findings and recommendations concerning the matters that were the subject of our review. The principal report is confidential but contains no classified information based on thorough, coordinated reviews of the information contained therein by the appropriate authorities within the Federal Bureau of Investigation, the Central Intelligence Agency, and the National Security Agency. The classified appendix likewise has been coordinated with those same agencies for classification purposes. We note that the classified appendix contains some information that is derived from Foreign Intelligence Surveillance Act authorities. According to the extent the department determines that it is appropriate to share information contained in the classified appendix with congressional or other government entities outside of the department, steps will need to be taken in accordance with that act and any relevant orders that have been issued by the Foreign Intelligence Surveillance Court. Finally, we want to thank you and your office for permitting our inquiry to proceed independently and without interference, as you assured the members of the Senate Judiciary Committee would be the case during your confirmation hearings to become Attorney General of the United States. This is just the table of contents. The report is submitted to the Attorney General. We read this already. Section 1 briefly describes the scope of our investigation. Section 2 is an executive summary of the report. Section 3 describes the laws and Department and Federal Bureau of Investigation policies that applied to or were addressed in our investigation. Section 4 summarizes the facts and evidence that we found and describes our prosecution and declination decisions. In Section 5, we provide some observations on issues pertinent to our areas of inquiry. 1. The Special Counsel's investigation. In March 2019, Special Counsel Robert S. Mueller III concluded his investigation into the Russian government's effort to interfere in the 2016 presidential election, including any links or coordination between the Russian government and individuals associated with the Trump campaign. That investigation did not establish that members of the Trump campaign conspired or coordinated with the Russian government in its election interference activities. Following the Mueller report, on May 13, 2019, Attorney General Barr directed United States Attorney John Durham to conduct a preliminary review into the certain matters related to the 2016 election campaign. And that review subsequently developed into a criminal investigation. On February 6, 2020, the Attorney General appointed Mr. Durham as Special Attorney to the Attorney General. On October 19, 2020, the Attorney General determined that, in light of the extraordinary circumstances related to these matters, the public interest warrants Mr. Durham continuing this investigation pursuant to the powers and independence afforded by the Special Counsel regulations. The Attorney General ordered the appointment of the Special Counsel in order to discharge the Attorney General's responsibility to provide supervision and management of the Department of Justice and to ensure a full and thorough investigation of these matters. The order stated, the Special Counsel is authorized to investigate whether any federal official, employee, or any other person or entity violated the law in connection with the intelligence, counterintelligence, or law enforcement activities directed at the 2016 presidential campaigns, individuals associated with those campaigns, and individuals associated with the administration of Trump, including but not limited to Crossfire Hurricane and the investigation of Special Counsel Robert S. Mueller III. So this is great. It's going to go into all this stuff. So this is perfect. This is why we're covering the Durham Report in the first place, because it really is the best source on all this stuff. If the Special Counsel believes it's necessary and appropriate, the order further provided the Special Counsel is authorized to prosecute federal crimes arising from his investigation of these matters. On December 21st, 2020, the Attorney General delegated certain authority to use classified information to the Special Counsel. After the inauguration of Biden, Attorney General Garland met with the Office of Special Counsel. The office very much appreciates the support consistent with his testimony during his confirmation hearings that the Attorney General has provided to our efforts and the department's willingness to allow us to operate independently. The Special Counsel structured the investigation in view of his power and authority to exercise all investigative and prosecutorial functions of any U.S. attorney, like a U.S. Attorney's Office, Special Counsel Office, considered in the course of its investigation a range of classified and unclassified information available to the FBI and other government agencies. The substantial amount of information and evidence was immediately available to the office at the inception of this investigation as a result of numerous congressional investigations and Special Counsel Mueller's investigation. The examinations by the Office of the Inspector General of the Crossfire Hurricane investigation, the Foreign Intelligence Surveillance Act, applications targeting Carter Page, and other matters provided additional evidence and information, as did an internal report prepared by the FBI's Inspection Division. The office reviewed the intelligence, counterintelligence, and law enforcement activities directed at the 2016 Trump campaign and individuals associated either with the campaign or with the Trump administration in its early stages. The office structured its work around evidence for possible use in prosecutions of federal crimes. Assuming that one or more crimes were identified that warranted prosecution, the office exercised its judgment regarding what to investigate, but did not investigate every public report of an alleged violation of law in connection with the intelligence and law enforcement activities directed at the 2016 presidential campaigns. In addition to the Special Counsel, the office has been staffed by experienced FBI and IRS Criminal Investigation Division agents, department attorneys, and prosecutors, support personnel, and contractor employees. The office's investigation was broad and extensive. It included work both domestically and overseas. It entailed obtaining large document productions from business firms, government agencies, universities, campaigns, internet service providers, telephone companies, and individuals. The office interviewed hundreds of individuals, many on multiple occasions. The office conducted the majority of interviews in classified settings. For some interviewees and their counsel's security clearances needed to be obtained. The office conducted interviews in person and via video link, with the vast majority of the latter occurring after COVID-19 pandemic-related closures began in March 2020. Although a substantial majority of individuals voluntarily cooperated with the office, some only provided information under a subpoena or grant of immunity. Some individuals who, in our view, had important and relevant information about the topics under investigation refused to be interviewed or otherwise cooperate. As of April 2023, with 2 trials completed, the office has conducted more than 480 interviews, obtained and reviewed more than 1 million documents consisting of more than 6 million pages, served more than 190 subpoenas, executed 7 search warrants, obtained 5 orders for communication records under this law here, 18 U.S.C., and made 1 request for a foreign government under a mutual legal assistance treaty. The office would like to express its appreciation to the FBI Office of General Counsel and Inspection Division, the Litigation Technology Support Services Unit in the National Security Division, the e-discovery team of the Office of the Chief Information Officer of the Justice Management Department, and the Justice Management Department's service delivery staff. The NSD and JMD entities created and maintained the databases and technology infrastructure needed to organize and review the large amount of data we obtained. The office would also like to express its appreciation to the Department's Office of Privacy and Civil Liberties for its guidance on appropriate information to include in a public report. The office has conducted its investigation into whether any federal official, employee, or any other person or entity violated the law in connection with the intelligence, counterintelligence, or law enforcement activities directed at the 2016 presidential campaigns, individuals associated with those campaigns, and individuals associated with the administration of Trump. This report is a summary. It contains, in the office's judgment, that information necessary to account for the special counsel's prosecution or declination decisions and describe the investigation's main factual results. It then sets forth some additional observations. The office made its criminal charging decisions based solely on the fact and evidence developed in the investigation and without fear or favor to any person. What is stated below in the Mueller report is equally true for our investigation. So it's just a quote here from the Mueller report that basically says it's non-biased. Conducting this investigation required us to consider U.S. criminal laws, the constitutional protections our system provides to individuals, and the high burden placed on the government to prove every element of a crime beyond a reasonable doubt. Moreover, the law does not always make a person's bad judgment, or even horribly bad judgment, standing alone a crime. Nor does the law criminalize all unseemly or unethical conduct that political campaigns might undertake for tactical advantage absent a violation of a particular federal criminal statute. Finally, in almost all cases, the government is required to prove a person's actual criminal intent, not mere negligence or recklessness, before that person's fellow citizens can lawfully find him or her guilty of a crime. The office's adherence to these principles explains in numerous instances why conduct deserving of censure or disciplinary action did not leave the office to seek criminal charges. There are also reasons why, in examining politically charged and high-profile issues such as these, the office must exercise special care. First, juries can bring strongly held views to the courtroom in criminal trials involving politicians, and those views can, in turn, affect the likelihood of obtaining a conviction, separate and apart from the strength of the actual evidence and despite a court's best efforts to impanel a fair and impartial jury. Second, even when prosecutors believe they can obtain a conviction, there are some instances in which it may not be advisable to expend government time and resources on a criminal prosecution, particularly where it could create the appearance, even if unfounded, that the government is seeking to criminalize the behavior of political opponents or punish the activities of a specific political party or campaign. At the same time, prosecutors should not shy away from pursuing justifiable causes solely due to the popularity of the defendant or controversial nature of the government's case. The principles of federal prosecution provide the following pertinent guidance on this point, which informed the special counsel's charging and declination decisions. So this is just like a quote from I guess the principles of federal prosecution, that kind of explains what I just read that says, like, here it gives an example. In a civil rights case or a case involving an extremely popular political figure, it might be clear that the evidence of guilt viewed objectively by an unbiased fact finder would be sufficient to obtain and sustain a conviction, yet the prosecutor might reasonably doubt based on his circumstances that the judge would convict. So it's basically saying, like, with political crimes, sometimes it's hard to bring it into court. The decision of whether to bring criminal charges to any given matter thus is a complicated one that is neither entirely subjective nor mechanistic. If this report and the outcome of the special counsel's investigation leave some with the impression that injustices or misconduct have gone unaddressed, it is not because the office concluded that no such injustices or misconduct occurred. It is rather because not every injustice or transgression amounts to a criminal offense, and criminal prosecutors are tasked exclusively with investigating and prosecuting violations of U.S. criminal laws, and even where prosecutors believe a crime occurred based on all the facts and information they have gathered, it is their duty only to bring criminal charges when the evidence that the government reasonably believes is admissible in court proves the offense beyond a reasonable doubt. Both Attorney General Barr and Garland have stated that one of their most important priorities is to ensure the proper functioning and administration of federal law by government agencies. Indeed, the first goal of the department's current strategic plan is to uphold the rule of law. And then it quotes the strategic plan here. In the aftermath of Crossfire Hurricane and the FISA surveillances of Page, the department has adopted other important policies. We discuss them and possible additional changes in portions of the report that follow. So here's a little Section 2 executive summary. The public record contains a substantial body of information relating to former President Trump and the Trump Organization's relationship with Russian businesses, Russian business people, and Russian officials, as well as separate evidence of Russia's attempt to interfere in the 2016 presidential election. These and related subjects are well documented in the careful examinations undertaken by the department's office of issues related to the FBI's Crossfire Hurricane investigation and its use of Foreign Intelligence Surveillance Act authorities. Former FBI Director Mueller, as detailed in his report entitled, this names the report, issued in 2019, and the Senate Select Committee on Intelligence entitled Russian Active Measures Campaigns and Interference in the 2016 U.S. election. The scope of these earlier inquiries, the amount of important information gathered, and the contributions they have made to our understanding of Russia election interference efforts are a tribute to the diligent work and dedication of those charged with the responsibilities of conducting them. Our review and investigation, in turn, is focused on separate but related questions, including the following. Was there adequate predication for the FBI to open the Crossfire Hurricane investigation as a full counterintelligence and foreign agents? So I guess, this report is going to try to say, should the FBI have even done Crossfire Hurricane in the first place? Was there enough evidence for them to actually open up an investigation? And I can't wait to get into that. That's going to be fun. Okay, so that's one question. Okay, so it continues. So, as a full counterintelligence and foreign agents registration act investigation, given the requirements of the Attorney General's guidelines for FBI domestic operations and FBI policies related to the use of the least intrusive investigative tools necessary, was the opening of the Crossfire Hurricane as a full investigation consistent with how the FBI handled other intelligence it had received concerning attempts by foreign interests to influence the Clinton and other campaigns? So this is like, did the FBI look into Trump biasly because they were like pro-Hillary? Similarly, did the FBI properly consider other highly significant intelligence it received at virtually the same time as that used to predicate Crossfire Hurricane, but which related not to the Trump campaign, but rather to a purported Clinton campaign plan to vilify Donald Trump by stirring up a scandal claiming interference by Russian security services, which might have shed light on some of the Russia information the FBI was receiving from third parties, including the Steele dossier, the Alpha Bank allegations, and the confidential human source reporting, if not for any provable federal crimes committed and failing to do so. So this is like something that we've heard before, that like Clinton used the FBI to like try to make it so people thought Trump colluded with Russia so that she could win the campaign. So I really can't wait to get into that as well. Was there evidence that the actions of any FBI personnel or third parties relating to the Crossfire Hurricane investigation violated any federal criminal statutes, including the prohibition against making false statements to federal officials? If so, was the evidence significant to prove guilt beyond a reasonable doubt? And then lastly, was there evidence that the actions of the FBI or department personnel in providing false or incomplete information to FISC violated any federal criminal statutes? If so, was there evidence sufficient to prove guilt beyond a reasonable doubt? Our findings and conclusions regarding these and related questions are sobering. Oh, okay. This is going to be so good. State of intelligence community information regarding Trump and Russia prior to the opening of Crossfire Hurricane. As set forth in greater detail, before this initial receipt by FBI headquarters of information from Australia on July 28, 2016 concerning comments reportedly made in a tavern on May 6, 2016 by George Papadopoulos, an unpaid foreign policy advisor to the Trump campaign. The government possessed no verified intelligence reflecting that Trump or the Trump campaign was involved in a conspiracy or collaborative relationship with officials of the Russian government. Okay, so that's great to see right here. So they're straight up saying it already. The Trump campaign was not involved in a conspiracy or collaborative relationship with officials of the Russian government. And I feel like a lot of people still think it is true that Trump did collude with Russia, but it's really not, and that's why we're going over the source in the first place. We're spreading awareness. Indeed, based on the evidence gathered in the multiple exhaustive and costly federal investigations of these matters, including the instant investigation, neither U.S. law enforcement nor intelligence committees appears to have possessed any actual evidence of collusion. The opening of Crossfire Hurricane. The record in this matter reflects that upon receipt of unevaluated intelligence information from Australia, the FBI swiftly opened the Crossfire Hurricane investigation, in particular at the direction of Deputy Director Andrew McCabe, Deputy Assistant Director for Counterintelligence Peter Strzok, opened Crossfire Hurricane immediately. He, at a minimum, had pronounced hostile feelings toward Trump. The matter was opened as a full investigation without ever having spoken to the persons who provided the information. Further, the FBI did so without any significant review of its own intelligence databases, collection and examination of any relevant intelligence from other U.S. entities, interviews of witnesses essential to understand the raw information it had received, or using any of the standard and analytical tools typically employed by the FBI in evaluating raw intelligence. So here it's saying the FBI didn't look into it before it opened up the investigation. They just went ahead with it. And also, one of the people that started the investigation, like, openly doesn't like Trump. Had it done so, again, as set out in sections here, the FBI would have learned that their own experienced Russia analyst had no information about Trump being involved with Russian leadership officials, nor were others in sensitive positions at the CIA, NSA, Department of State aware of such evidence concerning the subject. In addition, FBI records prepared by Strzok in February and March 2017 show that at the time of the opening of Crossfire Hurricane, the FBI had no information in its holdings indicating that at any time during the campaign, anyone in the Trump campaign had been in contact with any Russian intelligence officials. The speed and manner in which the FBI opened and investigated Crossfire Hurricane during the election season based on raw, unanalyzed, and uncorroborated intelligence is also reflected a noticeable departure from how it approached prior matters involving possible attempted foreign election interference plans aimed at the Clinton campaign. In the 18 months leading up to the 2016 election, the FBI was required to deal with a number of proposed investigations that had the potential of affecting the election. In each of those instances, the FBI moved with considerable caution. In one such matter discussed, FBI headquarters and department officials required defensive briefings to be provided to Clinton and other officials or candidates who appeared to be the target of foreign interference. In another, the FBI elected to end an investigation after one of its longtime invaluable CHSs went beyond what was authorized and made an improper and possibly illegal financial contribution to the Clinton campaign. Oh, on behalf of a foreign entity as a precursor to a much larger donation being contemplated. Okay, so what it's saying here is this investigation might have happened because, I mean, it's just saying here that a foreign entity donated to Clinton, and that could be one of the reasons the FBI got involved. I'm trying to understand this better. Let me look at it again. The FBI elected to end an investigation after a possibly illegal financial contribution to the Clinton campaign on behalf of a foreign entity. So there might be some bribery going on. I don't know. And in a third, the Clinton Foundation matter, both senior FBI and department officials placed restrictions on how those matters were to be handled, such that essentially no investigative activities occurred for months leading up to the election. So basically it's saying like the FBI was quick to open an investigation into Trump, but kind of suppressed looking into any investigations with the Clinton Foundation, which is like, you know, a political bias. The FBI is not supposed to do that. These examples are also markedly different from the FBI's actions with respect to other highly significant intelligence it received from a trusted foreign source pointing to a Clinton campaign plan to vilify Trump by tying him to Putin so as to divert attention from her own concernings related to her use of a private email server. Could be true. Unlike the FBI's opening of a full investigation of unknown members of the Trump campaign based on raw, uncorroborated information, in this separate matter involving a purported Clinton campaign plan, the FBI never opened any type of inquiry. Which, you know, that I'm so glad that we're going over this, because this report so far is laying out the groundwork for this like very well. And it is true that the FBI was quick to open this investigation on Trump, but doesn't do the same to the other side of the political spectrum, which kind of like shows a bias, which is bad, you know, obviously. The FBI never opened any type of inquiry, issued any tasking, employed any analytical personnel. You know, they didn't look into it. This lack of action was despite the fact that the significance of the Clinton plan intelligence was such as to have prompted the director of the CIA to brief the president, VP, Attorney General, director of FBI, and other senior government officials about its content within days of its receipt. It was also of enough importance for the CIA to send a formal written referral memorandum to Director Comey and the Deputy Assistant Director of the FBI's Counterintelligence Division for their consideration and action. The investigative referral provided examples of information the Crossfire Hurricane Fusion Cell had gleaned to date. Crossfire Hurricane investigation. Within days after opening the investigation, the FBI opened full investigations on 4 members of the Trump campaign team: George Papadopoulos, Carter Page, Paul Manafort, and Michael Flynn. No defensive briefing was provided to Trump or anyone in the campaign concerning the information received from Australia that suggested there might be some type of collusion between Trump and Russia, either prior to or after these investigations were opened. Instead, the FBI began working on requests to use the FISA authorities against Page and Papadopoulos. The effort as related to Papadopoulos proved unsuccessful. Similarly, the initial effort directed at Page was unsuccessful until the Crossfire Hurricane investigations first opened, which were designated as company intelligence reports generated by Christopher Steele. The Steele reports were first provided to the FBI in early June 2016, but for unexplained reasons only made their way to the Crossfire Hurricane investigations in mid-September. These reports were ostensibly assembled based on information provided to Steele and his company by a primary sub-source who the FBI eventually determined was Igor Danchenko. That sounds like a Russian agent. The investigation determined that the Crossfire Hurricane investigators did not and could not corroborate any of the substantive allegations contained in the Steele reporting. So I think that's the Steele dossier. Nor was Steele able to produce corroboration for any of the reported allegations, even after being offered $1 million or more by the FBI for such corroboration. So that's interesting. It was like $1 million by the FBI for information that corroborates what Steele reported on, but he didn't have anything. Further, when interviewed by the FBI in January 2017, Danchenko was unable to corroborate any of the substantive allegations in the reports. Rather, Danchenko characterized the information he provided to Steele as rumor and speculation and the product of casual conversation. So, like, if that's true, then yeah, there might be a good case here that the FBI did rush to open an investigation that was, like, unfounded when they didn't do that to Clinton, but they did it to Trump. Section here describes other efforts undertaken by the Crossfire Hurricane investigators working on the Page visa application. These efforts included having CHS's record conversations with Page, Papadopoulos, and a senior Trump foreign policy advisor. The FBI's own records and recordings established that Page made multiple exculpatory statements to the individuals identified, but the Crossfire Hurricane investigators failed to make that information known to the department attorneys or to FISC. Page also made explicit statements refuting allegations contained in the Steele reporting about this lack of any relationship with Paul Manafort, but the FBI failed to follow logical investigative leads related to those statements and to report on department lawyers what they found. Similarly, multiple recordings were made by CHS-1 and a second CHS in which Papadopoulos also made multiple exculpatory statements that were not brought to the attention of the department lawyers. Furthermore, our investigation resulted in the prosecution and conviction of an FBI OGC attorney for intentionally falsifying a document that was material to the FISC's consideration of one of the Page visa applications. Oh, that's very interesting. So yeah, it looks like some FBI guy made up a false document that kind of like helped speed up this investigation, helped get it going. And he actually got convicted of it, or she, it doesn't say who. Okay, the Steele dossier. In the spring of 2016, Perkins Coie, a U.S.-based international law firm acting as counsel to the Clinton campaign, retained Fusion GPS, a U.S.-based investigative firm, to conduct opposition research on Trump and his associates. So, like, this is, like, right here, this is, like, Clinton spying on the Trump campaign. Not like that's really illegal, but still, it's, like, a pretty shady thing to do. In mid-May 2016, Glenn Simpson met with Steele in the UK and retained Steele and his firm, Orbis Business Intelligence, to investigate Trump's ties to Russia. Steele described himself as a former intelligence official for the British government and was also at the time an FBI CHS. Beginning in July 2016 and continuing through December, the FBI received a series of reports from Steele and Orbis that contained derogatory information about Trump concerning Trump's purported ties to Russia. As discussed, Steele provided the first of his reports to the FBI handler on July 5th. These reports were colloquially referred to as the Steele dossier or Steele reports. As noted, it was not until mid-September that Crossfire Hurricane investigators received several of these reports. Within days of their receipts, the unvetted and unverified Steele reports were used to support probable cause in the FBI's visa applications targeting Page, a U.S. citizen who, for a period of time, was a Trump advisor. As discussed later in the report, this was done at a time when the FBI knew that the same information Steele had provided to the FBI had also been fed to the media and others in Washington, D.C. In particular, one allegation contained in an undated Steele report, identified as 2016-95, described a well-developed conspiracy of cooperation between Trump and Russia. The allegation would ultimately underpin the 4 FISA allegations targeting Page, specifically the allegations stated. So this is a quote from the Steele dossier. We're actually going to read it. Speaking in confidence to a compatriot, in late July 2016, Source E, an ethnic Russian close associate of Republican U.S. presidential candidate Trump, admitted that there was a well-developed conspiracy of cooperation between them and the Russian leadership. This was managed on the Trump side by Paul Manafort, who was using foreign policy advisor Carter Page and others as intermediaries. These two sides had a mutual interest in defeating Democratic presidential candidate Hillary Clinton, whom President Putin apparently both hated and feared. So this is interesting here. So this is kind of how the whole Russiagate stuff got started. It was an unnamed source that was Russian said that there was a conspiracy between Trump and Russia. But again, like, who is this guy? Bring him to court, have him testify under oath. You can't just say source E said it, so Trump's a Russian asset. You have to really prove that kind of stuff. Igor Danchenko, Steele's primary sub-source. As noted, the FBI attempted to investigate and analyze the Steele reports, but ultimately was not able to confirm or corroborate any of the substantive allegations contained in those reports. So yeah, this is pretty much it right here. Steele dossier was just like election juice to help boost like Clinton in the polls to help her win, but it was unfounded. But mainstream media and like social media just went with it, and that's kind of a problem. In the context of these efforts, and as discussed, the FBI learned that Steele relied primarily on a US-based Russian national, Igor Danchenko, to collect information that ultimately formed the core allegations found in the reports. Our investigation discovered that Danchenko himself had told another person that he was responsible for 80% of the intel and 50% of the analysis contained in the Steele dossier. In December 2016, the FBI identified Danchenko as Steele's primary sub-source. Danchenko agreed to meet with the FBI, and under protection of immunity, he and his attorney met with the Crossfire Hurricane investigators. Thereafter, from January 2017 through October 2020, and as part of its efforts to determine the truth or falsity of specific information in the Steele reports, the FBI conducted multiple interviews of Danchenko regarding the information he provided to Steele. During those interviews, he was unable to provide any corroborating evidence to support the Steele allegations, and further described the interactions with his sub-source as rumors and speculation and conversations of casual nature. Significant parts of what Danchenko told the FBI were inconsistent with what Steele told the FBI during his prior interviews in October 2016 and September 2017. At no time was the FISC informed of these inconsistencies. Moreover, notwithstanding the repeated assertion in the page visa applications that Steele's primary sub-source was based in Russia, Danchenko for many years had lived in D.C. While after learning that Danchenko continued to live in the Washington area, it had not left for domestic and foreign travel, the FBI never corrected this assertion in the 3 subsequent page visa renewal applications. Okay, so it's saying here the FBI knew that this guy lived in DC, he wasn't actually traveling to Russia, but they still let these visas get renewed. Rather, beginning in March 2017, the FBI engaged Danchenko as a CHS and began making regular financial payments to him for information, none of which corroborated Steele's reporting. So they knew that he wasn't traveling to Russia, but they were still paying him for information. The unresolved prior FBI counterintelligence investigation of Danchenko, I do like his name. The FBI knew in January 2017 that Danchenko had been the subject of an FBI counterintelligence investigation from 2009 to 2011. In late 2008, while he was employed by the Brookings Institution, he engaged 2 fellow employees about whether one of the employees might be willing or able in the future to provide classified information in exchange for money. According to one employee, Danchenko believed that he, the employee, might be following a mentor into the incoming Obama administration and have access to classified information. During this exchange, Danchenko informed the employee that he had access to people who are willing to pay for classified information. The concerned employee passed this information to a U.S. government contact, and the information was subsequently passed to the FBI. Based on this information, in 2009, the FBI opened a preliminary investigation into Danchenko. The FBI converted its investigation into a full investigation after learning that Danchenko had been identified as an associate of 2 FBI counterintelligence subjects and had previous contact with the Russian embassy and known Russian intelligence officers. Also, at that earlier time, agents had interviewed several former colleagues of Danchenko who raised concerns about Danchenko's potential involvement with Russian intelligence. For example, One colleague who had interned at a U.S. intelligence agency informed the office that Danchenko frequently inquired about that person's knowledge of a specific Russian military matter. So it's just saying here, this Danchenko guy is known for asking people like, hey, do you have any classified information? Send me it because I know people that will buy it off you. And they knew that before they paid him as an informant for like the Crossfire Hurricane. They should have known that he's probably not a reliable source of information, but they still used him as a source. Meanwhile, in July 2010, the FBI initiated a request to use FISA authorities against Danchenko, which was substantially routed to department attorneys in August 2010. However, the investigation into Danchenko was closed in 2011 after the FBI incorrectly concluded that Danchenko had left the country and returned to Russia. That's interesting. So they thought that he left, so they stopped the investigation, but apparently he didn't. Our review found no indication that the Crossfire Hurricane investigations ever attempted to resolve the prior Danchenko espionage matter before opening him as a paid CHS. Moreover, our investigation found no indication that the Crossfire Hurricane investigators disclosed the existence of Danchenko's unresolved counterintelligence investigation to the department attorneys who were responsible for drafting the FISA renewal applications targeting Carter Page. As a result, the FISC was never advised of information that very well may have affected the FISC's view of Steele's primary subsource and Steele's reliability and trustworthiness. So what they're saying here is the FISC like wasn't aware that this Danchenko guy could have been like a Russian informant, and if the FISC was aware that they might not have opened up the like investigation into Trump, but they weren't aware because the FBI didn't tell them. It appears the FBI never gave appropriate consideration to the possibility that the intelligence Danchenko was provided to Steele, which again, according to Danchenko himself, made up a significant majority of the information in the Steele dossier reports was, in fact, or in part, Russian disinformation. That's really fun stuff. So, like, I feel like a lot of people kind of think that when people say Trump didn't collude with Russia, like, that's Russian disinformation. But it looks like the real Russian disinformation is how the whole Russiagate thing started. Because Danchenko used a lot of those, like, unfounded claims, and that made up the Steele dossier, which opened up Operation Hurricane, and you know that was the real Russian disinformation. Danchenko's relationship with Charles Dolan. So I don't know this name, Charles Dolan. Let's check it out. Danchenko maintained a relationship with Dolan, a Virginia-based public relations professional who had previously held multiple positions and roles in the DNC. Oh, okay. In his role as a public relations professional, Dolan focused much of his career interacting with Eurasian clients with a particular focus on Russia. As described, Dolan previously conducted business with the Russian Federation and maintained relationships with several key Russian government officials, including Dmitry Peskov, and powerful press secretary of the Russian presidential administration. A number of these Russian government officials with whom Dolan maintained a relationship and was in contact with at the time Danchenko was collecting information for Steele would later appear in the dossier. In the summer and fall of 2016, at the time Danchenko was collecting information for Steele, Dolan traveled to Moscow, as did Danchenko, in connection with the business conference. As discussed, the business conference was held at the Ritz-Carlton, Moscow, which according to the Steele reports was allegedly the site of salacious sexual conduct on the part of Trump. Danchenko would later inform the FBI that he learned of these allegations through Ritz-Carlton staff members. Our investigation, however, revealed that it was Dolan, not Danchenko, who actually interacted with the hotel staff identified in the Steele reports. So between the two, Dolan appears the more likely source of the allegations. Our investigations also uncovered that Dolan was the definitive source for at least one allegation in the Steele reports. This allegation concerned the circumstances surrounding the resignation of Paul Manafort from the Trump campaign. When interviewed by the office, Dolan admitted that he fabricated the allegation about Manafort that appeared in the Steele report. Our investigation also revealed that Dolan independently received other information strikingly similar to the allegations that would later appear in the Steele reports. Nevertheless, when interviewed by the FBI, Danchenko denied that Dolan was a source for any information in the reports. Furthermore, during the relevant time period, Dolan maintained a business relationship with Olga Galkina, a childhood friend of Danchenko, who, according to Danchenko, was a key source for many of the allegations. In fact, Galkina was interviewed by the FBI in August 2017. She admitted to providing Dolan with information that would later appear in the Steele reports. So it looks like this Dolan guy was lying to the FBI. The FBI's failure to interview Charles Dolan. Our investigation revealed that Crossfire Hurricane investigators were aware of Dolan and his connections to Danchenko in the Steele reports. In early October 2016, Steele informed the FBI Dolan was a person who might have relevant information about Trump. The FBI interviewed hundreds of individuals through the course of Crossfire Hurricane and later investigations, and yet it did not interview Dolan as a possible source of information about Trump. Our investigation interviewed Dolan on several occasions, as well as the two other persons mentioned by Steele. Dolan initially denied being a source of information for the reports. When, however, he was shown a particular Steele report relating to Paul Manafort and his resignation as Trump's campaign matter, along with related emails between himself and Danchenko, he acknowledged to the office that he fabricated this information. Although both Steele and Olga suggested to the FBI that Dolan may have information related to the reports, our investigation was not able to definitively show that Dolan was an actual source, whether wittingly or unwittingly, for any additional allegations set forth. Regardless, of light of the foregoing, there does not appear to have been objectively sound reason for the FBI's failure to interview Dolan. Danchenko's claims regarding Sergei Milian. Perhaps the most damning allegations in the Steele dossier reports was Company Report 2016-95, which Steele attributed to Source E as one of Danchenko's supposed subsources. This report, portions of which were included in each of the 4-page FISA applications, contributed to the public narrative of Trump's conspiring and colluding with Russia. Danchenko's alleged sources for the information was an individual by the name of Sergei Milian, who was the president of the Russian-American Chamber of Commerce in New York City and a public Trump supporter. The evidence uncovered by the office showed that Danchenko never spoke with him and simply fabricated the allegations where he attributed to Milian. When interviewed by Crossfire Hurricane investigators in late July 2017, Danchenko said source E, which is Sergei Milian, sounded as though he was Sergei Milian. As described, Danchenko stated that he never actually met him. Instead, that in late July 2016, he received an anonymous call from a person who did not identify himself, but spoke with a Russian accent. Danchenko further explained that he thought it might have been Milian, someone Danchenko previously had emailed twice and received no response. After watching a YouTube video of Milian speaking, the total support for the Source E information contained in the Steele report is a purported anonymous call from someone Danchenko had never met or spoken to, but who he believed might be Sergei, a Trump supporter, based on listening to a YouTube video of Sergei Milian. Unfortunately, the investigation revealed that instead of taking even basic steps such as securing telephone call records, the Crossfire Hurricane investigators appear to have chosen to ignore this and other red flags concerning Danchenko's credibility. That Source E that said that Trump colluded with Russia, they don't even know who that was. They can't even confirm who it is. The Alpha Bank allegations. The office also investigated the actions of Perkins Coie attorney Michael Sussman and others in connection with Sussman's provision of data in white papers to FBI General Counsel James Baker, purporting to show that there existed a covert communications channel between the Trump organization and a Russia-based bank called Alpha Bank. As set forth, in doing so, he represented to Baker by text message and in person that he was acting on his own and was not representing any client or company in providing the information to the FBI. Our investigation showed, in point of fact, these representations to Baker were false in that Sussman was representing the Clinton campaign. In addition, Sussman was representing a second client, a technology executive named Rodney Joff. Cyber experts from the FBI examined the materials given to Baker and concluded that they did not establish what Sussman claimed they showed. Sussman made a separate presentation regarding the Alpha Bank allegations to another U.S. government agency, and It too concluded that the materials did not show what Sussman claimed. In connection with that second presentation, Sussman made a similar false statement to that agency, claiming that he was not providing the information on behalf of any client. Okay, interesting. With respect to the Alpha Bank materials, our investigation established that Joff had tasked a number of computer technology researchers who worked for companies he was affiliated with and who had access to certain internet records to mine the internet data to establish an interference and narrative tying then candidate Trump to Russia. In directing these researchers to exploit their access in this manner, Joff indicated he was seeking to please certain VIPs in context referring to individuals at Perkins Coie who were involved in campaign matters in the Clinton campaign. During its investigation, the office also learned that after the 2016 presidential election, he emailed an individual and told that person that he, Joff, was tentatively offered the top cybersecurity job by the Democrats when it looked like they'd win. So this could be like a bribery thing, like the Clinton campaign or like DNC was like, yo, find us some evidence Trump colluded with Russia and we'll give you a cushy job.
Talking about the Steele dossier?
Dude, reading the whole thing, brother?
Reading the whole Steele dossier?
No, I'm reading the Durham Report, but it quotes a lot of the Steele dossier.
Which is paid for by Hillary Clinton.
Yep.
And her campaign funds.
Yep,
which is why she received a fine.
That's probably why you haven't heard about her the last couple of years. She's scared.
Well, she almost did the same thing that Trump did, and Trump got 34 felonies for every like payment / invoice of paying back Michael Cohen, whereas Hillary paid the Steele dossier out of her campaign finance funds and labeled it like lawyer fees or something. And so essentially the same thing, misusing campaign finance funds to do something that wasn't labeled correctly, and instead she just got a fine.
Yeah, it's kind of ridiculous. As explained, the evidence collected by the office also demonstrated that prior to providing the unfounded Alpha Bank claims to the FBI, Sussman and Fusion GPS, the Clinton campaign's opposition research firm, had provided the same information to various news organizations and were pressing reporters to write articles about the alleged secret communications channel. So this is kind of where like the media gets involved here.
This is huge if we're talking about like the Steele dossier and everything, because this is exactly what prompted the FBI and other agencies to start investigating the Trump campaign. However, they then use those investigations once FBI launches the Trump investigation to then give credence to those articles. Right, and so it's like circular based on just improper misinformation.
Yeah, it's misinformation.
Right? And so that's what ultimately lets the FISA courts get their warrants to wiretap Trump and his associates. Is all based off of fake hit pieces in the media that are then used to open an investigation.
Yeah, this is what Clinton does. Moreover, during his September 2016 meeting at the FBI, Sussman told Baker that an unnamed news outlet was in possession of the information and would soon publish a story about it. The disclosure of the media's involvement caused the FBI to contact the news outlet, whose name was eventually provided by Sussman in the hope of delaying any public reporting on the subject. In doing so, it confirmed for the New York Times that the FBI was looking into the matter, and on October 31st, 2016, less than 2 weeks before the election, the New York Times and other published articles on the Alpha Bank matter and the Clinton campaign issued tweets and public statements on the allegations of a secret channel of communications being used by Trump and a Russian bank. Allegations that had been provided to the media and the FBI by Fusion GPS and Sussman, both of whom were working for the Clinton campaign. So that's fun stuff.
So look at that. That's exactly what I just said.
Yeah.
Was that the Clinton campaign had these hit pieces written and published in prominent media outlets. And then those media outlets, their publications prompted the FBI to then launch an investigation, which they then said substantiated these fake hit pieces.
And it's funny because the New York Times and Washington Post both got Pulitzer Prize for reporting on the Russian interference in 2016. So it's just like another way, like the New York Times and Washington Post like reported that, Trump was colluding with Russia, and they got Pulitzer Prizes for those articles. And there is a lawsuit right now. Trump's suing them. So he's suing the Pulitzer Prize Board to redact those awards because it was misinformation.
And don't forget, the Washington Post, which was purchased by Jeff Bezos, has a $500 million deal with the CIA. Right? The CIA paid them $500 million, and under the guise of creating some cloud computing network or something to that degree. Government has given the Washington Post $500 million.
That's super fun.
That just means that there's some conflict of interest there.
Absolutely. Yeah, absolutely. Conclusion. Based on the review of Crossfire Hurricane and related intelligence activities, we conclude that the department and the FBI failed to uphold their important mission of strict fidelity to the law in connection with certain events and activities described in this report. As noted, former FBI attorney Kevin Kleinsmith committed a criminal offense by fabricating language in an email that was material to the FBI obtaining a FISA surveillance order. In other instances, FBI personnel working on that same FISA application displayed at best a cavalier attitude towards accuracy and completeness. FBI personnel also reportedly disregarded information requirements when they continued to seek renewals for the FISA surveillance while acknowledging, both then and in hindsight, that they did not genuinely believe there was probable cause to believe that the target was knowingly engaged in clandestine intelligence activities on behalf of a foreign power, or knowingly helping another person in such activities. And such personnel disregarded significant exculpatory information that should have prompted investigative restraint and re-examination.
Basically, what that is saying is people like Kleinsmith from these intelligence agencies, I believe the FBI specifically, they lied. They lied to the FISA court during this process. Kleinsmith, I believe, was already sent to jail or something for a little bit. I believe. I'm not sure. But it's because they lied in these documents to the FISA court, I believe 17 times. And these were all to acquire those wiretaps on Trump and his associates during the campaign. And it was all just a lie. I believe this Kleinsmith was convicted of this.
Yeah, and that's kind of, we saw this in the news lately. Tulsi Gabbard came out and said those when they spied on Trump, when they got those FISA warrants, they obtained them illegally, and this is kind of what she's talking about. I mean, it looks like she's not wrong.
Yep, so here we go. Former FBI attorney Kevin Kleinsmith received only a year sentence, 400 hours of community service, and I think some probation.
Wow, he got off.
Yep, he got off, but admitted that he sent an altered email to an FBI agent that indicated a target of a court-ordered FBI surveillance. Former Trump campaign advisor Carter Page was not a source for the Central Intelligence Agency. So he lied, saying that Carter Page was not giving information to the CIA when Carter Page actually was.
Yeah, and that's how they ended up tapping the Trump administration guy's phone through a fake warrant like that.
So when everyone laughed at Fox News or whatever, which there's tons of reasons to laugh at Fox News, but when they said that there was a wiretap on Trump, or Trump said that somewhere, Trump said that they had a wiretap, and people were making fun of Trump, saying, "No, you can't wiretap." Oh, there was actually a wiretap obtained by the FISA court, which does not let people know when there's anything going against them. It does not inform them of anything of anything that's going on with them. It's a secret court, right? So there was, in fact, 17 falsehoods that were given to this court that allowed them to get the wiretap on Trump, which was illegal, which is the whole reason why Trump is going after Obama and Obama is now suing Trump.
Yep. Yeah. Super fun stuff. And the FBI even became aware that some of the reasons that they obtained the FISA court wiretaps in the first place, they kind of learned that, oh shit, those original claims might be wrong, but they still kept renewing the wiretaps. The FBI.
Yep. Because that's the evidence of the exculpatory evidence. They didn't look into the fact where these sources came from for these news articles. Instead, use that as a cue to start investigation, which then these news media outlets like the Washington Post were like, "Oh, the FBI is investigating. We were right," and so they were building this lie on top of each other, using the
Yeah.
other one as credibility to substantiate these claims
Yeah, I mean,
when it was all just lies.
New York Times, Washington Post, they've got Pulitzer prizes for those articles. But it's like fake news, like actual.
And these documents, and the fact that this is still going on, and the fact that Kevin Kleinsmith, he was sentenced to 12 months of probation and 400 hours community service, no prison time. But he was still convicted in a court of law for doing these things.
Yeah. Our investigation also revealed that senior FBI personnel displayed a serious lack of analytical rigor towards the information that they received, especially information received from politically affiliated persons and entities. This information in part triggered and sustained Crossfire Hurricane and contributed to the subsequent need for special counsel Mueller's investigation. In particular, there was significant reliance on investigative leads provided or funded directly or indirectly by Trump's political opponents. The department did not adequately examine or question these materials and the motivations of those providing them, even when, at about the same time, the director of the FBI and others learned of significant and potential contrary intelligence.
That basically means is that they knew that Hillary Clinton paid for the Steele dossier, and no one asked questions about it.
Yeah. In light of the foregoing, there is a continued need for the FBI and the department to recognize that lack of analytical rigor, apparent confirmation bias, and an overwillingness to rely on information from individuals connected to a political opponent caused investigators to fail to adequately consider alternative hypotheses and to act without appropriate objectivity or restraint in pursuing allegations of collusion or conspiracy between a U.S. political campaign and a foreign power. Although recognizing that in hindsight much is clear, much of this also seems to have been clear at the time. We therefore believe it is important to examine past conduct to identify shortcomings and improve how the government carries out its most sensitive functions. Section 5 discusses some of these issues more fully. This report does not recommend any wholesale changes in the guidelines or policy that the department and the FBI now have in place. Rather, it is intended to accurately describe the matter that fell under our review and to assist the Attorney General in determining how the department and the FBI can do a better, more credible job in fulfilling its responsibilities and in analyzing and responding to politically charged allegations in the future. Ultimately, meeting those responsibilities comes down to integrity of the people who take an oath to follow the guidelines and policies currently in place, guidelines that date from the time of Attorney General Levy and that are designed to ensure the rule of law is upheld. As such, the answer is not the creation of new rules, but a renewed fidelity to the old. The promulgation of additional rules and regulations to be learned in yet more training sessions would likely prove to be a fruitless exercise if the FBI's guiding principles of fidelity, bravery, and integrity are not ingrained in the hearts and minds of those sworn to meet the FBI's mission of protecting the American people and upholding the Constitution. So yeah, they're kind of saying like they don't need to make new rules. FBI just needs to like not get politically.
No, this is all bullshit saying, "Oh, we're sorry, even though we fucked up and created huge issues that could be considered as some form of election interference. We're sorry. We'll do better. We need to do better." That's what they just said.
Yeah, they're just saying they need to have more integrity because yeah, like it just wasn't credible, this investigation, like the how this investigation got started. So the FBI really should have looked into it more, realized, hey, like these sources aren't reliable, but they didn't do that because they probably wanted Clinton to win.
Because this probably was politically motivated.
Yeah, and if you want to get a promotion, you do this for Clinton, and then she wins. It's what is it? You do something for me, I do something for you. Quid pro quo.
Let's not forget the one thing that we all have to remember is the only reason Trump even became like a potential presidential nominee is because of Clinton and their Pied Piper strategy. The Clinton campaign decided to give money to Trump and elevate him and give him airtime because they wanted to get a candidate so ridiculous that there would be no way that the normal Republican base would vote for them, so they would have to vote for Clinton. And this is what happened. They sank money into the Trump campaign in order to prop them up, and then they have to sink more money into the Trump campaign in order to delegitimize the election because of how much they fucked up.
That's great. We'll definitely do an episode on that, the Pied Piper Clinton stuff.
Pied Piper strategy.
Yeah, we'll definitely do an episode on that.
An email recently released by whistleblower organization WikiLeaks shows how Clinton campaign and Democratic Party bear direct responsibility to Trump, blah, blah, blah. And the self-described Pied Piper strategy, Clinton campaign proposed intentionally cultivating extreme right-wing presidential candidates, hoping to turn them into new mainstream of the Republican Party in order to try to increase Clinton's chances of winning.
Yeah, which is a legitimate strategy that the Democrats actually do. They've done it more than once. They do it in like the midterms. Sometimes they'll.
Well, that's a very popular thing that people do in the midterms. In fact, one of the Trump attempted assassinations was perpetrated by a person who is largely seen as a Democrat because they spouted Democratic talking points or something and voted for Act Blue, and their family was Democrat or something, and then they registered in the Republican Party. And this is a major contention point is people say he's Republican because he voted to vote in the Republican Party, or he registered as a Republican, and that's because this is a common tactic is when people are in like a far left district or a far left county or state, blue state, and they know that their candidate is going to win, they will sometimes join the other party to then toss their votes and spoil it for the major Republican candidate, which a lot of people were doing to go vote for people like Nikki Haley in the last election.
Yeah, people do that all the time. Like, say you're a Democrat, you'll still show up to like the Republican primaries to vote for like the worst Republican candidate so that your Democratic candidate in the election has a better chance of winning.
Absolutely. And this has been something that people have been doing for decades.
I
remember hearing about this when I was a child in the 2000s.
Yeah, absolutely. People do it all the time. Section 3, applicable laws and Department and FBI policies. This section begins by summarizing some of the principles of federal prosecution which govern all federal prosecutions. Next, the section describes the laws and policies that we considered in the course of our investigations. These include the requirements that apply to the FBI's assessments and investigations of counterintelligence matters, most of which are found in guidelines promulgated by the Attorney General and FBI policies and the legal standards for conducting electronic surveillance under FISA. This section concludes by describing the principal statutes that we use to evaluate possible criminal conduct for prosecution. And it says here, they use false statements, perjury, falsification of records, violation of civil rights, conspiracy, fraud against the U.S., campaign contributions, money laundering, transmission of classified information. So in this section, if it starts just describing laws, like all this stuff, like U.S. or 18, like United States Code, we might not read all of this. We really want the juice from the Durham Report. We don't want to read laws from like other documents. So just a heads up on that. Principles of federal prosecution. In deciding whether to exercise prosecutorial authority with respect to the statutes discussed below, the office has been guided by the principles of federal prosecution set forth in the Justice Manual. These principles include determination to prosecute. A determination to prosecute represents a policy judgment that the fundamental interests of society require the application of federal criminal law to a particular set of circumstances. The attorney for the government should commence or recommend federal prosecution if they believe that the person's conduct constitutes a federal offense and that the admissible evidence would probably be sufficient to obtain and sustain a conviction. unless the prosecution would serve no substantial federal interest, the person is subject to effective prosecution in another jurisdiction, or there exists an adamant non-criminal alternative to prosecution. Substantial federal interest. In determining whether a prosecution would serve a substantial federal interest, the attorney for the government should weigh all the relevant considerations, including federal law enforcement priorities, including any federal law enforcement initiatives or operations aimed at accomplishing those priorities, the nature or seriousness of the offense, the deferred effect of prosecution, the person's culpability in connection with the offense, the person's history with respect to crime, the person's willingness to cooperate, the person's personal circumstances, the interest of the victims, and the probable sentence or other consequences if the person is convicted. Okay, so right here, this is describing all the principles of a federal prosecution. So this is going to be more of a skim here. So like the third principle is most serious, readily provable offense. So like, they take the most serious offense and make sure they prosecute that.
The ones that they know are serious and that they know are going to be able to achieve a prosecution.
Yeah, and the ones they probably have, yeah, exactly. Unpopularity, where the law and the facts create a sound, prosecutable case, the likelihood of an acquittal due to unpopularity of some aspect of the prosecution or because of the overwhelming popularity of the defendant or her cause is not a factor prohibiting prosecution. So yeah, it says maybe if charging them would be unpopular, like publicly, maybe they won't do it.
It's crazy.
Yeah. Interest of uncharged parties. In all public filings and proceedings, federal prosecutors should remain sensitive to the privacy and reputation interest of uncharged third parties. In the context of public plea and sentencing proceedings, this means in the absence of some significant justification, it is not appropriate to identify or cause a defendant to identify a third party unless the party has been officially charged with the misconduct at issue. So they're not trying to, bring any third parties that didn't do wrongdoing into the case.
You can plead the fifth for yourself and other people, I guess.
Yeah. As a series of cases makes clear, there is ordinarily no legitimate governmental interest served by the government's public allegation of wrongdoing by an uncharged party. And this is true regardless of what criminals may say, be contemplated by the assistant United States attorney against the third party for the future. Courts have applied this reasoning to preclude the public identification of unindicted third-party wrongdoers in plea hearings, sentencing memoranda, and other government pleadings. In a similar vein, Deputy Attorney General Rosenstein stated that we do not hold press conferences to release derogatory information about the subject of a declined criminal investigation. He went on to say that derogatory information sometimes is disclosed in the House of Criminal Investigations and Prosecutions, but we never release it gratuitously. What is this, section B? The FBI's assessment and investigation of counterintelligence matters. This subsection describes the requirements that apply to the FBI's assessments and investigations of counterintelligence. The AGG-DOM gives the FBI a broad mandate to detect, obtain information about, and prevent and protect against federal crimes and threats to national security. These crimes and threats include espionage, other intelligence foreign intelligence activities, and foreign computer intrusions. It gives the FBI a broad mandate to detect, obtain information, and prevent and protect against federal crimes and threats to the national security. These crimes and threats include espionage and other activities and foreign computer intrusions. It provides that these guidelines do not authorize investigating or collecting or maintaining information on United States persons solely for the purpose of monitoring activities by the First Amendment or the lawful exercise of other rights secured by the Constitution or laws of the U.S. Use of least intrusive means, so they don't go straight for like say they're investigating someone, they won't go straight for like a warrant and search all your stuff. They might like wiretap you first or something. Levels of investigation. One significant way that the AGG-DOM and the DIOG implement the least intrusive means requirement is by describing 4 different levels of activity. The first is activity that the FBI may conduct with any formal opening or authorized possession and is referred to as activities authorized prior to opening an assessment. The other, more formalized levels of activity are assessments, preliminary investigation, and full investigation. As the level increases, the FBI may use a broader range of techniques. And then here it kind of describes each level. So activity authorized before opening an investigation. So they'll probably do stuff, like they could do certain things here before they go and get like actual warrants. That's kind of what this is describing. Assessment. So I guess they got to start here with activities they can do before they open an assessment. Then there is an assessment, preliminary investigation. After that, it's full investigation. 3, the confidential human source guidelines. So yeah, this goes over guidelines of probably like informants and stuff. In addition to the AGG-DOM, the Attorney General has approved separate guidelines governing the FBI's use of human sources. The guidelines in place at the time of Crossfire Hurricane required the validation of a CHS when the person was opened as a source. Validation included documenting the person's criminal record and motivation for providing info. Because a source's reliability can change, the guidelines directed the FBI to review each CHS's file at least annually and ensure that all available information that might materially alter a prior validation assessment is promptly reported to a supervisor and documented. The guidelines also require that FBI agents instruct the CHS because the instructions are important. Another target or official was to be present as a witness. The agent was to direct the CHS to provide truthful information and to abide by the instructions of the FBI. If the FBI compensated the CHS was liable for any taxes that may be owed. The guidelines explained that the content or meaning of each of the instructions must be clearly conveyed to the CHS. Immediately afterward, the agent shall require the CHS to acknowledge it. Next is the analytical integrity. It talks about the FBI's counterintelligence division. It's an operational component, whereas a separate directorate of intelligence provides analytical support. Next up, we have recently upgraded protections. So investigative activities. The Sensitive Investigations Memorandum promulgated by the Attorney General in 2020 imposes additional approval requirements for politically sensitive activities. The FBI takes exploratory investigative steps relating to a presidential candidate, a senior staff member, or an advisor. It must give prompt written notice to the appropriate Assistant Attorney General and the U.S. Attorney. The Attorney General explained that this includes any person who has been publicly announced by a campaign as a staffer or member of an official campaign advisory committee or group. The same notice requirements applies if the FBI opens an assessment of such a person. If the FBI opens a preliminary or full investigation of such a person, then notice to the department is not enough. The Attorney General must approve the opening of the investigation. The memorandum also directs department components to review their existing policies governing notification, consultation, and/or approval of politically sensitive investigations, providing a summary of those policies and recommend any changes or updates necessary. The department to study after the 2020 elections its experiences and consider whether changes to the requirements in the memorandum are necessary. The Attorney General recently reaffirmed the need to adhere to the requirements of the Sensitive Investigation Memorandum that governed the opening of criminal and counterintelligence investigations by the department related to politically sensitive individuals and entities. CHS Guidelines and Policy. In 2020, following various OIG reviews, the FBI undertook a comprehensive review of the 2006 CHS guidelines to ensure that the FBI's source validation process was hopefully refocused, revised, and improved across the FBI. So the new one, the 2020 CHS guidelines, provide additional direction for the FBI in handling of human sources. They require info about whether the CHS is reasonably believed to be a current or former subject or target of an FBI investigation. So that hopefully will help. So like this kind of stuff doesn't happen in the future. They kind of revised how they use these sources, and they made it so that it's more strict. So they require info about whether the CHS is reasonably believed to be a current or former subject or target of an FBI investigation. There is also a new requirement for information about a source's reporting relationship with other government agencies. At the time when the Attorney General approved the guidelines, he also directed that pending further guidance, he or the Deputy Attorney General must approve any use of a CHS to target a federal elected official or political campaign for the purposes of investigating political or campaign activities. So it looks like if this were to happen again, the FBI would have to name the sources, the human sources, the informants, to the Attorney General or the Deputy Attorney General. So maybe like those people can take a look at it and make sure that like the sources are credible before like the investigation moves forward. So I think it's just a way to try to make sure this doesn't happen again. Here it talks more about their confidential human source policy guide, and it talks about the requirements, identifying the specific source-related activities in which FBI intelligence analysts and other non-agent personnel may engage, requiring information about all likely motivations the CHS would have for providing info, enhancing the requirements for source validation reviews, requiring detailed information and additional approvals, and a request to reopen a CHS who was previously closed for cause, either by the FBI or another agency. Finally, it requires the CHS to be treated as sensitive and thus subject to more controls based on either the position the source holds or the position held by someone the source is reporting on. Defensive briefings. The OIG's review of Crossfire Hurricane discusses defensive briefings for those who may be targets of nefarious activities by foreign powers, and specifically at the time of the investigation, the possibility of conducting a defensive briefing for the Trump campaign on Russian activities. The review says that we did not identify any department or FBI policy that applied to its design, and therefore determined that the decision whether to conduct defensive briefings in lieu of opening an investigation or at any time during an investigation was a judgment call that is left to the discretion of FBI officials. It went on to suggest that it would be desirable to give senior department leadership the opportunity to consult with the FBI about whether to conduct a defensive briefing in a circumstance such as this one. The department and the FBI have taken steps to address this issue. First, the Attorney General has instructed the FBI Director to promulgate procedures concerning defensive briefings. The purpose of this requirement is to address concerns that U.S. persons may have unwitting participants in an effort by a foreign power to influence an election or the policy or conduct of the government. Second, the FBI has established a Foreign Influence Defensive Briefing Board. The FBI is continuing its newly implemented review process for foreign influence defensive briefings, in particular briefings to legislative and executive branch officials. So this is again, the FBI saying, okay, we're not going to let this happen again. We have like new policy so that it hopefully doesn't happen again. This would be pretty juicy. The Foreign Intelligence Surveillance Act, FISA. So this is how they get the like wiretaps and stuff, through like FISA warrants. And so this should be pretty juicy. FISA permits the government to seek authority from the FISC and use a range of investigative techniques for the installation and use of pen register and trap and trace devices, which are relatively unintrusive. FISA requires that the information likely to be obtained is relevant to an FBI investigation. For electronic surveillance, which is among the most intrusive techniques available to the FBI, the requirements are more extensive. We describe below some of the findings required by the statute. FISA's First Amendment proviso and the certification by a high-ranking executive branch official. This subsection concludes by summarizing some of the executive branch's requirements for FISA applications, many of which have been added in recent years. So it's required findings. FISA requires the government to submit an application describing the target of the surveillance, the techniques used, and other matters. And then the FBI agent has to swear to the truth of the facts. The FISC may authorize electronic surveillance if there is probable cause to believe that the target of the surveillance is an agent of a foreign power. For a U.S. person, there are at least 2 additional related requirements. First, as a matter of principle, no United States citizen should be targeted for electronic surveillance absent some showing that he at least may violate the laws of our society. So they have to show like evidence that the person getting surveyed did like a crime to get like electronic surveillance, like a wiretap. Second, the person must be knowingly engaged in the specified conduct. Thus, a U.S. person may be an agent of a foreign power if the person is knowingly engaged in clandestine intelligence gathering activities on behalf of a foreign power or knowingly helping another person in such activities, provided that the activities involve or may involve a violation of U.S. criminal law. The House report goes on to explain how foreign powers may engage both in intelligence gathering and other nefarious intelligence activities. Not only do foreign powers engage in spying in the U.S. to obtain info, they also engage in activities which are intended to harm the nation's security by affecting the course of our government, the course of public opinion, or activities of individuals. Some activities may include political action, recruiting, bribing, influencing, disguised propaganda, including the planting of false or misleading articles or stories, that's like fake news, harassment, intimidation, or even assassinations. Such activity can undermine our democratic institutions as well as directly threaten the peace and safety of our citizens. Consistent with this discussion, a U.S. person engaged in political action or other non-intelligence gathering activity may also fall within the definition of an agent of a foreign power. This is the case if the person knowingly aids or abets or conspires with any person who works for intelligence or a network of a foreign power or engages in intelligence activities for such a foreign power, which activities involve or are about to involve a violation of the criminal statutes of the U.S. Because these other activities may come closer to activity protected by the First Amendment, the required level of criminal involvement is higher in this definition. The House report explains that the activities engaged in must presently involve or be about to involve a violation of federal criminal law. The House report also discusses the aiding or abetting provision at length and says that FISA allows surveillance of any person, including a U.S. person, who knowingly aids or abets any person in the conduct of activities described. The report goes on to explain how the earlier surveillance of MLK, which was justified based on his association with the members of the Communist Party, would not meet this standard. Oh, that's fun. Maybe we'll go into MLK in a different episode about how he was spied on by the government. The King excerpt underscores the need for the target to be knowingly furthering the criminal clandestine intelligence activities of those whom he is aiding, but it also explains that such knowledge may be inferred. Protection of First Amendment activities. In enacting FISA, Congress recognized that there may often be a narrow line between covert actions and lawful activities undertaken by Americans in the exercise of their First Amendment rights. FISA thus includes a provision similar to the one found in the AGG DOM and prohibits any U.S. person from being considered an agent of a foreign power solely upon the basis of activities protected by the First Amendment. The House report explains that this provision is intended to reinforce the intent of the committee that lawful political activities should never be the sole basis for a finding of probable cause to believe that a U.S. person is an agent of a foreign power. Certification by executive branch official. Oh, so this is here to get these FISA requirements. An executive branch official has to certify it. So I don't think it has to be the president, but at least someone, an official of the president. It could be like the director of the FBI, like someone like that, or a similar official, like the U.S. Attorney General, probably. I think it said that earlier. So yeah, they have to certify it. Executive branch requirements. Over 20 years ago, the FBI adopted procedures designed to ensure the accuracy of the information contained in the FISA application. These are often referred to as the Woods procedure after their principal author. The recent OIG reviews of the page and other FISA applications raise concerns about compliance with the Woods procedures and the accuracy and completeness of the information in FISA applications. As a result, the department has made numerous filings with the FISC, and the FISC has also directed that changes be made. So for all applications, the FBI now requires that both an agent and a supervisor must affirm that the Office of Intelligence of NSD, which represents the government before the FISC, has been apprised of all information that might reasonably call into question the accuracy of the info in the application or otherwise raise doubts about the requested probable cause findings or the theory of the case. Before the candidate files an application for electronic surveillance of a federal elected official, a candidate for federal office, or a staffer of such a person, the Attorney General has directed that the FBI field office not involved in the investigation must review the case. The Attorney General also has imposed other limitations on applications for electronic surveillance in politically sensitive matters. Defensive briefings. Before they file an application with the FISC, the FBI director must consider conducting a defensive briefing on the target. Then either the FBI must conduct a briefing, or if the director determines that such a briefing is not appropriate, the director must document that determination in writing. This is in addition to the general requirements described above for the FBI to establish procedures for defensive briefings. Duration of surveillance. So they may seek an FISC surveillance for 60 days. Oh, the max is 60 days. This is shorter than the statutorily permitted 90-day maximum for surveillance of a U.S. person. In addition, every 30 days, the government must report to the FISC on the results of the surveillance and the continued need for the activity. Statutes used to evaluate possible criminal conduct. The first is a standard of proof. Second, false statements. So they kind of have to verify that any statements made are actually true. Perjury. It says that whoever, having taken an oath before a competent tribunal, officer, or person in any case in which a law of the U.S. authorizes an oath to be administered, that he will testify, declare, depose, or certify truly that any written testimony by him subscribed is true, willfully, and contrary to such oath states or subscribes any material matter which he does not believe to be true, or in any declaration, certificate, verification, or statement under penalty of perjury is admitted under the United States Code, willfully subscribes as true any material matter which he does not believe to be true, is guilty of perjury. Okay, so it's saying that the information that they get from these informants needs to be true, or else that is perjury if they testify it. Falsification of records. So it's a crime to falsify records, is what it's saying here. Obstruction of justice. There are several statutes that cover conduct intended to obstruct or impede government investigation. And then here it talks about it. There's two of them here. Oh, it talks about the Mueller report. So there's this U.S. Code 1512C2 is an omnibus obstruction of justice provision that covers a range of obstruction acts directed at impeding or contemplating official proceedings. This part here also offers broad protection against obstructive acts directed at pending grand jury, judicial, administrative, and congressional proceedings, and they are supplemented by a provision in Statement 512B aimed specifically at conduct intended to prevent or hinder the communications to law enforcement or information related to a federal crime. The Mueller report describes these requirements and noted that 3 basic elements are common to the obstruction statutes pertinent to the office's charging decisions: an obstructive act, some form of nexus between the obstructive act and an official proceeding, and criminal intent. Violation of civil rights. So it's a crime for anyone acting under color of law willfully to deprive any person of a right secured by the Constitution or laws of the U.S. The government must prove 3 elements beyond a reasonable doubt to obtain a conviction. First, the defendant deprived the person of an identified right. Second, the defendant acted willfully, that is, the defendant committed such an act or acts with a bad purpose to disobey or disregard the law. Third, the defendant acted under the color of law. Acting under the color of law means act done under any state law, county or city ordinance, or other governmental regulation, and acts done according to a custom of some governmental agency. It means that the defendant acted in his or her official capacity or else claimed to do so, but abuse or misuse his or her power by going beyond the bounds of lawful authority. Conspiracy to violate civil rights. It's a crime to conspire to deprive a person of his or her civil rights. General conspiracy statute. It requires the U.S. Code requires the government to prove 4 elements beyond a reasonable doubt. First, 2 or more persons in some way agreed to try to accomplish a shared and unlawful plan. So it would be for conspiracy. There has to be at least 2. Second, the defendant knew the unlawful purpose of the plan and willfully joined. Third, during the conspiracy, one of the conspirators knowingly engaged in at least one overt act as described in the indictment. And fourth, the act was committed at or about the time alleged and with the purpose of carrying out or accomplishing some object of the conspiracy. Campaign contributions. So U.S. Code provides that no person shall make contributions to any candidate and his authorized political committees with respect to any election for federal office which in the aggregate exceed $2,000. And then it is that $2,000 is adjusted for inflation, stating that limitations for contributions by persons to federal candidates are adjusted every 2 years. The limit for an individual donor to a candidate committee for the 2015 and 16 election cycle was $2,700. And then if you violate this, it could be a crime if the violation involved at least the amount specified in a calendar year and the violation was committed knowingly and willfully. Campaign contributions for foreign nationals. So it's a crime for a foreign national, directly or indirectly, to make a contribution or donation of money or other thing of value, or to make an express or implied compromise to make a contribution or donation in connection with the federal election. Fraud against the United States. So the U.S. Code imposes criminal liability on whoever knowingly executes or attempts to execute any scheme or artifice with the intent to defraud the U.S. or to obtain money or property by means of false or fraudulent pretenses, representations, or promises in any grant, contract, or other form of federal assistance if the value of such grant, contract, or other form of federal assistance is $1 million or more. The government must prove 3 elements beyond a reasonable doubt to obtain a conviction. They got to prove the defendant knowingly did it, that there was a scheme, because this is part of the. Okay, sorry. First, that the defendant knowingly did it or tried. Second, the scheme took place as a part of acquiring property, services, or money. Third, the value of the contract or subcontract was $1 million or more. Money laundering. Whoever, knowingly that the property involved in a financial transaction represents the proceeds of some form of unlawful activity, conducts or attempts to conduct a financial transaction which in fact involves the proceeds of specified unlawful activity with the intent to promote the carrying on of specified unlawful activity or intent to engage in conduct constituting a violation of the Internal Revenue Code. To obtain a conviction, the government must prove the following 3 things: that the defendant conducted a financial transaction involving property constituting the proceeds of specifically unlawful activity, the defendant knew that the property involved was the proceeds of some form of unlawful activity, and the defendant acted either with the intent to promote the carrying on of specified unlawful activity or with the intent to engage in violating certain provisions of the Internal Revenue Code. The U.S. Code imposes criminal liability on whoever knowingly engages or attempts to engage in monetary transaction and criminally deprive property of value greater than $10,000 and is derived from specified unlawful activity. And then it says how they obtain a conviction for that. That did they engage in it? Was it over $10,000? And was it derived from specified unlawful activity? And did they know that the transaction was involved with the proceeds of a criminal offense and the transaction took place in the U.S. or the defendant is a U.S. person? And finally, the U.S. Code imposes criminal liability on any person who conspires to commit any offense defined in Section 1956 or 1957 to obtain a conviction under the Section 1956H. The government must prove the following 3 elements: that 2 or more persons reached an agreement to commit one of the offenses, the defendant voluntarily and intentionally joined in with the agreement, the defendant joined in with the agreement or understanding, she knew the purpose of the disagreement or understanding. Disclosure of national defense information. So it's a crime. The U.S. Code imposes criminal liability on whoever lawfully having possession of access to, control over, or being entrusted with any document, writing, code book, or signal book, sketch, photograph, photographic negative, blueprint, plan, map, model, instrument, appliance, or note relating to the national defense, or information relating to the national defense, which information the possessor has reason to believe could be used to the injury of the United States or to the advantage of any foreign nation, willfully communicates, delivers, transmits, or causes to be communicated, delivered, or transmitted, or attempts to communicate, deliver, transmit, or cause to be communicated, delivered, or transmitted the same to any person not entitled to receive it, or willfully retains the same and fails to deliver it on demand to the officer or employee of the United States entitled to receive it. Modern federal jury instructions summarize the elements that the government must prove beyond a reasonable doubt to obtain a conviction: that the document was related to national defense, the defendant had reason to believe the document could be used to the injury of the U.S. or to advantage foreign government. Fourth, that on the date the defendant willfully communicated the document to the name of the person who was not entitled to receive it. Background facts and prosecution decisions. This section begins by providing factual information about the FBI's New York field office investigation on Carter Page in the spring of 2016. The text message between certain FBI officials that on their face show a predisposition to investigate Trump, and the predication, opening, and conduct of the Crossfire Hurricane investigation. This part concludes with a comparison of the Trump of the FBI's investigative decisions related to Clinton with some of those related to Trump. The remaining parts of this section each include a factual background and then describe the prosecution decisions the office made. The first addresses an investigative referral of a possible Clinton campaign plan. The next one is an extensive discussion of the FISA application targeting Page. The last part of this section covers conduct by private sector actors in connection with Crossfire Hurricane and related subjects. In describing these matters, the section does not endeavor to repeat or restate all the information that the office and others have covered and made public. Instead, it aims to add to that body of info, including additional relevant facts, and explain the prosecutive decisions we made. The appointment order authorized a special counter to prosecute federal crimes arising from this investigation of the matter assigned to him, which is stated in the Mueller report as equally true for our investigation. In deciding whether to exercise this prosecutorial authority, the office has been guided by the principles of federal prosecution set forth in the Justice Manual. In particular, the office has evaluated whether the conduct of the individuals considered for prosecution constitutes a federal offense and whether admissible evidence would probably be sufficient to obtain and sustain a conviction for such an offense. Where the answer to those questions was yes, the office further considers whether the prosecution would serve a substantial federal interest. These individuals were subject to the effective prosecution in another jurisdiction, and there existed an adequate non-criminal alternative to prosecution. These considerations, as explained below, led the office to charge 3 individuals with making false statements. The office considered whether other individuals made false statements to the FBI, the OIG, or congressional committees, or whether during the course of the office's investigation, other individuals interviewed, either omitted material or provided false information. Again, what is stated in the Mueller report is also true for our investigation. The office determined that other matters it investigated either did not involve the commission of a federal crime or that our evidence was not sufficient to obtain a criminal conviction. In addition to its prosecution and declination decisions, the office made the following referrals to other entities. A referral on June 30th, 2020 to the FBI's Washington field office regarding a matter relating to an existing counterintelligence investigation. A referral in December 2020 to OI of information relevant to the accuracy of information contained in 4 non-page FISA applications. Referrals of 2 matters on December 14th, 2022 to the Inspector General of the Department of Defense with a copy to the General Counsel of the Defense Intelligence Agency. 1 matter involved the execution of a contract between DARPA and the Georgia Institute of Technology, and a separate matter involved the irregular conduct in 2016 of 2 former employees of the Department of Defense. A referral to the FBI's OGC and Inspection Division of an FBI agent for failing to document properly the known history of Igor Danchenko upon his opening as an FBI CHS. A referral to the FBI's OGC and Inspection Division in the same FBI agent for questionable instructions given to Danchenko regarding the taxability of cash payments made to him by the FBI. In addition to the referrals described below, the office also provided information to the FBI's Inspection Division regarding certain activities by current and former FBI employees. Okay, let's continue. So, the Crossfire Hurricane investigation. New York Field Office investigation of Page. In late March 2016, Carter Page, an American energy consultant, was named a foreign policy advisor to the Donald Trump 2016 presidential campaign. Page's prior business experience was largely focused on Russia and Eurasian energy issues, and as such, he frequently interacted with various Russian nationals. Based on his previous Russian contacts, Page was known to the FBI and had been interviewed on 3 occasions between 2009 and 2013 by the New York Field Office. In 2015, Page was again interviewed by the FBI in connection with the indictment of 3 Russian intelligence officers in the Russian intelligence officers in the Southern District of New York. According to the criminal complaint and subsequently returned indictment in that case, Page had been approached by the intelligence officers in an apparent failed recruitment effort. In the criminal complaint, one intelligence officer referred to Page anonymized as male as an idiot, and Page does not seem to have been receptive to the recruitment efforts. Page was interviewed by prosecutors as a possible government witness in that case. One defendant, Evgeny Barikov, pleaded guilty before trial and was sentenced to 30 months of imprisonment. The two other defendants in the case were protected by diplomatic immunity and are no longer in the United States. In April 2016, shortly after Page was named as an advisor to the Trump campaign, the New York field office opened a counterintelligence investigation of him. According to the case agent in the matter, in opening the investigation, the FBI was not so concerned about Page, but rather it was concerned about the Russians reaching out to Page. Moreover, the field office case agent told the offices that there were no plans to seek FISA coverage on Page. The agent and her FBI supervisor informed the OIG that Page's role as a foreign policy advisor did not influence their decision to open a case on Page. It may, however, have affected the timing of the case opening and increased interest in him. Indeed, Director Comey had earlier in April requested relevant information pertaining to any presidential candidate. In line with that directive, Comey was briefed on the Page investigation, which a week later was described as a top priority for the director. At that time, FBI personnel in Washington prepared a counterintelligence report on Page for the director. In July, the same personnel described the Page case and ones like it as a top priority for Comey. In any event, despite Page's role as a publicly named foreign policy advisor, the FBI did not open the investigation as a sensitive investigative matter, or SIM. A few months later, shortly after the FBI opened the Crossfire Hurricane investigation at FBI headquarters and the 4 subfiles, including on Page, the New York field office's investigation of Page was transferred to the Crossfire Hurricane investigation at the FBI headquarters. Evidence of predisposition to investigate Trump. The record reviewed by the office demonstrated a rather clear predisposition on the part of at least certain FBI personnel at the time of Crossfire Hurricane to open an investigation of Trump. For example, Peter Strzok and Lisa Page were directly involved in matters related to the opening of Crossfire Hurricane. Strzok was the agent who both wrote and approved the electronic communication opening the matter from the very start as a full investigation rather than an assessment or preliminary investigation. At the time, Page was serving as Deputy Director Andrew McCabe's special assistant, and according to Strzok, it was McCabe who directed that the Crossfire Hurricane investigation be opened immediately after information described more below was received from Australian authorities in late July 2016. Over a period of months prior to the opening of Crossfire Hurricane, Strzok and Page had exchanged numerous messages which are already in the public domain and express a very clear prejudice against Trump. Oh, cool. So right here, we're going to go over some examples by these two people, Strzok and Page. They have some text messages here of what they said, and they're saying these messages express a very clear prejudice against Trump. So Strzok and Lisa Page, it looks like they're both FBI agents. So August 16th, 2015, Strzok says a message, Bernie Sanders is an idiot like Trump. December 20th, 2015, after exchanging an article about Trump, Page says, what an utter idiot. Strzok says, no doubt. March 13th, 2016, Page says, God, Trump is a loathsome human. Strzok, yet he may win the Republican nomination. Good for Hillary. Page, it is. Strzok, would he be a worse president than Cruz? Page, Trump, yes, I think so. Strzok, I'm not sure. Oh my God, Trump's an idiot. Page, he's awful. America will get what the voting public deserves. Page, that's what I'm afraid of. So it's just messages here that show that these two agents that were doing the Crossfire Hurricane stuff that opened the case are not fans of Trump. They don't like him. Strazak, God, Hillary should win 100 million to 0. May 13th, 2016. Page, and holy shit, holy fuck or something, they cut it out. Cruz just dropped out of the race. It's going to be a Clinton-Trump race. Unbelievable. Strazak, what? Page, you heard that right, my friend. Strazak, I saw Trump won, figured it would be a bit. Now the pressure really starts to finish. The Clinton email investigation. Okay, so he's saying right here, oh shit, it looks like Trump's going to be the nominee. We really got to finish this Clinton email investigation, most likely, so it looks better for her during the election. And then Page, it sure does. July 18th, 2016, during the Republican National Convention, Strazak, oh, turn it on, turn it on. The douchebags are about to come out. You can tell by the excitable clapping. Page, and wow, Donald Trump is an enormous douche. July 19th, 2016, Strazak, hi. How was Trump other than a deuce? Page, Trump barely spoke, but the first thing out of his mouth was, we're gonna win so big. The whole thing is like living in a bad dream. July 21st, 2016. Strazak, Trump is a disaster. I have no idea how destabilizing his presidency would be. July 27th, 2016. Page, have we opened on him yet? Trump and Putin? Yes, it's really a thing. And then it links an article. We'll probably pull that article up, see if it's still up. Strazak opened on Trump. If Hillary did, 5 field offices would, ... So he's kind of saying, oh, wait for Hillary to like start the investigation on Trump. Shit, I lost what page I was on. Okay, so this article here where Page says, have we opened on him yet? Trump and Putin? And she sends Strazak an article that has been taken down. And then Strazak responds with, like, if Hillary opened an investigation on him, 5 field offices would as well. As discussed more fully below, the next day, July 28, 2016, FBI headquarters received the Australian information that formed the basis for the opening of Crossfire Hurricane. On Sunday, July 31st, 2016, Strazak, as he has written, he was directed to do by McCabe, immediately opened Crossfire Hurricane. He both drafted and approved the Crossfire Hurricane opening. So it's the very next day after Page asks him, like, hey, have we opened an investigation on yet? The very next day, he opens the investigation and approves it, but he says that McCabe directed him to do it. So I wonder if that's actually true or not. So this is after the investigation had been opened. So this is August 8th, 2016. Page, Trump's not going to become president, right? Strazak, no, he's not. We'll stop it. So that looks like some illegal activity right there. This is some deep state stuff right here. We got these FBI actors trying to stop Trump from winning the election by opening this investigation. Similarly, and is discussed in more detail below, FBI OGC attorney Kevin Kleinsmith made troubling statements demonstrating a blatant political bias against Trump. Kleinsmith, who played a central role in the Page FISA process on the day after Trump's election as president, stated to fellow FBI personnel, among other things, "Vive la resistance," an obvious reference to those individuals opposed to Trump. Although those involved in opening the Crossfire Hurricane investigation denied that bias against Trump was a factor in opening the investigation, the communications quoted above quite clearly show, at least on the part of certain personnel intimately involved in the matter, a predisposition to open an investigation into Trump. Yeah, that's true. The opening of Crossfire Hurricane. The FBI opened Crossfire Hurricane as a full counterintelligence investigation to determine whether individuals associated with the Trump campaign were witting of and or coordinating activities with the government of Russia. The starting point for the office's inquiry was to examine what information was known or available to the FBI about any such ties as of July 31st, 2016, prior to opening Crossfire Hurricane. That question then divided itself into two related questions. What was the information that predicated the opening of the investigation? And did the information support such an investigation being opened not as an assessment or preliminary investigation, but form the start of a full investigation? In exploring these questions, we determined the following. The information used to predicate Crossfire Hurricane. In March 2016, the Trump campaign identified George Papadopoulos as a foreign policy advisor. He had previously worked as an energy consultant with a particular focus on projects in the Eastern Mediterranean. At the time of his appointment, he was employed in the United Kingdom at the London Centre of International Law Practice. Among his acquaintances in London was a diplomat from another country. Foreign Government One Diplomat One was familiar with an Australian diplomat. On May 6, 2016, by prearrangement, Foreign Government One Diplomat One introduced Papadopoulos to Australian Diplomat One. On May 10th, 2016, Papadopoulos and Australian Diplomat One met again, and this time they were joined by Australian High Commissioner Alexander Donner. Both meetings were over drinks in public settings. The Australian diplomats were interested in meeting with him because of his role in the Trump campaign, and much of the conversation centered on the upcoming election. Over 2 months later, on July 26, 2016, Australia provided the U.S. Embassy in London certain information its diplomats had memorialized at or around the time of the meetings with Papadopoulos. The next day, the State Department passed this information on to the FBI's legal attaché assigned to the embassy in London. Paragraph 5 was the name given to the raw information provided by the Australian government and included in a May 16, 2016 cable that documented the diplomats' encounters with Papadopoulos. Paragraph 5 is an abstract from the cable and was quoted verbatim in the Crossfire Hurricane opening EC, stating in its entirety that Mr. Papadopoulos was confident that Mr. Trump could win the election. He commented that the Clintons had a lot of baggage and suggested the Trump team had plenty of material to use in its campaign. He also suggested the Trump team had received some kind of suggestion from Russia that it could assist the process with the anonymous release of information during the campaign that would be damaging to Mrs. Clinton and President Obama. It was unclear whether he or the Russians were referring to material acquired publicly or through other means. It was also unclear how Mr. Trump's team reacted to the offer. We noted that Trump's team's reaction could, in the end, have little bearing of SIC what Russia decides to do with or without Mr. Trump's cooperation. The Australian account reflects that 2 meetings of a casual nature took place with Papadopoulos. These meetings were documented by Donner on May 11, 2016, and by Australian Diplomat One later in the month. Both diplomats advised that prior to the spring of 2016, Papadopoulos was unknown to them. Notably, the information in paragraph 5 does not include any mention of the hacking of the DNC, the Russians being in possession of emails, or the public release of any emails. In addition, when interviewed by the office, Donner stated that he would have characterized the statements made by Papadopoulos differently than Australian Diplomat One did in paragraph 5. According to Donner, Papadopoulos made no mention of Clinton emails